Welcome to the classroom. Please like, share, and subscribe to our channel.
A strike is a situation where two or more employees participate in the action. These people do not have to work for the same employers. The most important thing is that they must have a common work-related issue. For it to be a strike, it can be a partial or a complete refusal to work. Examples of this include go-slows, which is the permanent state of all ShopRite cashiers, work to room, which you may experience at your nearest Labour Department office, overtime bans or intermittent strikes, where the strike action starts and stops over and over a period of time. For a strike to be regarded as protected, certain conditions must be met. Any collective agreement regarding dispute resolution procedures must be followed. If there is no agreed dispute resolution procedure, then the procedures of the Labour Relations Act must be followed. 1. The issue in dispute must be referred in writing to the CCMA, a bargaining council or a statutory council. 2. The CCMA or council must try to settle the dispute through conciliation within 30 days. 3. If this fails, the CCMA or council must issue a certificate saying that the dispute has not been resolved. And finally, 4. At least 48 hours notice in writing of the proposed strike must be given to the employer, or 7 days notice if the state is the employer. A strike will not be considered protected if a collective agreement specifically states that the workers may not strike over the issue at hand, the correct procedures have not been followed, or if the arbitration decision is ignored. The parties are engaged in an essential service. During a protected strike, you as an employer are not allowed to dismiss the employees who go on strike. However, if they do certain things which may be considered as misconduct, such as acts of intimidation and violence, then hey, you are allowed to summon your inner Donald Trump and fire those people. As an employer, you may apply for a court interdict to stop damage to property or any unlawful actions. No work, no pay rules may apply. As per the LRA, essential services such as the police, the parliamentarians, or any services where the interruption of said service may endanger the lives, personal safety, or health of any part of the population, then these people are not allowed to go on strike. Other forms of industrial action may include 1. Picketing, which is held at a place where the public has access, such as the outside of the premises of the employer. This action, however, has to be peaceful. 2. Secondary action or sympathy strikes are situations where employees strike in support of other workers who are striking. However, they must give their employer 7 days notice and the main strike must be protected. Unfair discrimination will not be tolerated if it is on the basis of race, gender, sexual orientation, age, disability, religion, political opinion, culture, language, marital status, or family responsibility. Keep in mind, however, that there is some discrimination that the law makes provision for. Think affirmative action, which we will talk about a bit more when we discuss employment equity and the broad-based Black Economic Empowerment Act. Under the LRA, an employee would be regarded as unfairly dismissed when an employer ends a contract of employment without notice to the employee. An employer refuses to allow an employee to return to work after maternity leave. Constructive dismissal takes place. This means that the employer makes the working environment impossible for the employee to tolerate, which forces the employee to resign. An employee is dismissed because he took part in the activities of a trade union or workplace forum. An employee is dismissed when taking part in a protected strike or protest action. An employee is dismissed due to pregnancy or any reason related to her pregnancy. The employee is dismissed on arbitrary grounds, such as the employee's race, age, except when retirement age is reached, of course, religion, sex, sexual orientation, or family responsibilities. As important as discipline is in a school environment, so it is in the work environment. This will ensure that order is maintained and problems are minimized. For an employee to be disciplined, the process must be procedurally fair and at the least substantiatively fair. For a disciplinary procedure to work, it must follow the guidelines of the Labor Relations Act, and an employee must also be given the opportunity to defend themselves through a representative or by themselves. Reasons for dismissal may include the following: misconduct, incapacity where the employee cannot properly complete their duties over a prolonged period of time, operational reasons which could be beyond the control of the employee. Remedial actions which may follow disciplinary actions will include: 1. Reinstatement, which means giving the employee their jobs back. However, bear in mind that the employee is allowed to refuse to take their work back. The working relationship may be so badly damaged or reinstatement becomes impractical. 2. Compensation, where you, the employer, must pay a specified amount or a number of months' salary to the employee. 3. A combination of both the prior solutions as per the instructions of the CCMA. The Basic Conditions of Employment Act of 1997. The purpose of the BCEA is that it provides minimum standards for the employment contracts which will govern the relationship between employer and employee. From there, it will regulate the rights of fair labor practice as envisioned in the Constitution, and it will then adhere to the rules of labor as set out by the International Labour Organization. The positives which are created by the BCEA are: it provides a framework of acceptable practices for the business. This will refer to the minimum guidelines of standards and fair labor practices, such as working hours and contractual agreements. It promotes fair treatment of employees. It encourages constant consultation with employees and employers. The negatives of the BCEA are: drafting contracts which will adhere to the Act may be time-consuming and they may also be very expensive. If the business chooses to not meet the guidelines of the Act, then this could lead to situations of non-compliance. Unfortunately, or fortunately, depending on which side of the fence you are on, no employer may force an employee to work more than 45 hours a week. This could have many implications for you as a business owner. The exploitation of affordable labor theoretically became impossible with this act. What could be viewed as discriminatory as far as this act is concerned? The BCEA makes it forbidden for workers to discuss their pay grades with others. The logic here is quite simple: jealousy and conflict. Not giving employees access to their employment contracts may be regarded as discriminatory. Refusing to accept a sick note from an employee may be seen as discriminatory. With great discrimination, there will also be great penalties. What are they in the case of this act? A compliance order may be served upon your business. this order will come from the Department of Labor. Investigations may be conducted on the labor practices of your company, and obviously, this will prove to be time-consuming. The Director General may institute or cancel any compliance orders ordered upon your business. As a non-compliant business, the likelihood is high that you could be taken to the labor court, and if this happens, your business may be liable to pay heavy fines and other penalties.
Thank you for joining us in this lesson. If you learned something, give the video a like, share, and subscribe for more great content.